May it please the court, my lord, I also still appear on behalf of Mr. Wallace.
Good morning, my lord. Kabayi from Kabayi Attorneys, appearing on behalf of Mr. Stephen O'Fandrain in this matter. Confirm that these are to the instructions.
Thank you.
Thank you, my lord.
Good morning, my lord. I confirm that I shall appear on behalf of Joshlin.
Good morning, my lord. Eben van Toonder, I'm appearing on behalf of the Section 204 witness, Ms. Lombard.
Good morning, everyone. Just a few housekeeping and some explanations on the process so that everybody knows how we're going to do it. I see there's still some space in the second row. So if any members of the media or people that want to come closer, you may utilize that space. I know that the area behind the cameras on the left, that's normally reserved for the media, is quite small and you can't see from there. So feel free to utilize that space. There's some concern this morning that the message went out that the court will start at 9. The courts in Cape Town start at 10. It was only when I sat out in Saldanha that we started earlier, just to clear that confusion. There's been some delay in scheduling this hearing, as we had to synchronize the diaries of everybody and to get the logistics in place. The main issue for the delay was that Mr. Van Tonder, who appeared for Ms. Lombard in the preparatory phase of her becoming a Section 204 witness, had no further mandate from Legal Aid South Africa to appear on her behalf. We attempted to secure instructions at my insistence for Mr. Van Tonder to appear on Ms. Lombard's behalf. That failed. I then requested Mr. Van Tonder as an officer of the court to offer his services pro bono to assist Ms. Lombard. And I'm indebted to Mr. Van Tonder in agreeing to assist Ms. Lombard further in the process. I will therefore deal with the two issues in the following sequence. I will hear argument from Mr. Van Tonder as to why I should grant Ms. Lombard the indemnity in terms of Section 204 of the Criminal Procedure Act. And then I will excuse Mr. Van Tonder after he has made his input. Then I will proceed with the arguments on the applications for leave to appeal, starting with Mr. Harmse, and then hear the state on both aspects, being the applications for leave to appeal, as well as their stance on the question of indemnity. The indemnity inquiry is a separate inquiry, and both the state and Ms. Lombard has an interest in that outcome. Therefore, the state needs to be heard on that. The primary reason for Ms. Lombard having to be represented, in my view, is because it affects her rights. And in order to give a fair hearing, I insisted that she be legally represented. Any other housekeeping, Ms. Swanepoel?
Nothing from us, thank you, my lord.
Mr. Armisen?
Nothing from my side, my lord.
Mr. Kabai,
Nothing from my side, my lord.
Mr. Signorine.
Nothing from my side.
Thank you. Mr. Van Tonder, as a start, you provided me with some references.
Indeed, sir, my lord.
I thought the two cases that deals with the law, that's the latest Constitutional Court judgment in Makala,
Indeed, sir, my lord.
and what I perceive to be an important judgment. It's a judgment from the Free State High Court in Kayla,
Indeed, sir, my lord.
distinguishing the procedure that was followed in Muhammad in KZN.
Yes, my lord.
So I did not deem it necessary to bring copies of that into the courtroom. I've also found an interesting article way back in 2003, published in the South African Law Journal, in the second volume of 2003 at 373. It's the article that the judge in the Free State referred to in that judgment in a footnote. It's the article of Theophilopoulos
Yes, my lord.
on the parameters and proceedings performed.
As a court pleases, my lord.
But of course the starting point will be section 204.
Indeed, sir, my lord. And before the court, I'll prepare some oral arguments, my lord.
Certainly.
My lord, the court has already made reference to the background of the case and my involvement since the inception, so I will not labor the court's time further to dwell on that. I will then jump straight to the issues to be decided by the Honourable Court and also the desired outcome on behalf of the applicant today. My lord, the issue to be decided by the Honourable Court is whether to grant the witness immunity from prosecution in terms of Section 204, subsection 2 of the Criminal Procedures Act 51 of 1977. The desired outcome would be a ruling in favour of granting such immunity from prosecution to the witness, Ms. Lombard, on all charges as stipulated in the indictment, as well as all competent verdicts thereto. Regarding the law and then also arguments in favour of granting immunity to the witness, as already mentioned, my lord, Section 204, subsection 2 finds application here, and I'll just briefly quote that subsection. If a witness referred to in subsection 1 is in the opinion of the court, if in the opinion of the court answers frankly and honestly to all questions put to him, such witness shall, subject to the provisions of subsection 3, be discharged from prosecution for the offence so specified by the prosecutor, and from which any offence in respect of which a verdict of guilty would be competent upon a charge relating to the offence so specified, and B, the court shall cause such discharge to be entered on the record of proceedings in question. Well, before I proceed, I must also just mention that in preparing my arguments, to my knowledge, the Honourable Court's written judgment is not yet published, so I did go on to the media broadcast and the court's live judgment at the time of trial, which was archived in one of the news sites, and I've listened to the court's judgment there and based my arguments upon the court's verbal judgment at the time. Having referred to subsection 2 of Section 204, my lord, I would submit with respect that it is clear from the text of the Act that this is a peremptory provision, and I respectfully submit that if in the opinion of this Honourable Court the witness answered frankly and honestly to all questions, then immunity must follow as a matter of law. It is submitted with respect, my lord, that the inquiry to establish on a balance of probabilities whether the witness answered all questions frankly and honestly as stipulated by the Act. I would refer the Honourable Court to the matter of State versus Kaler, 2016, Volume 2, South African Criminal Reports, page 563, just the Free State decision. And I will also just note here, my Lord, that this case was also cited by the Constitutional Court in the matter of Mawanda Makala and another versus Director of Public Prosecutions, Western Cape, citation 2024, ZACC 28 at paragraph 43.
Of course, it was cited with approval
Indeed, Your Lord.
on the principles and the distinction between the approach taken by the court in Mohammed, the KZN decision.
Indeed, Your Lord.
But of course, the facts very different.
Indeed, sir. It's based on the principles, Your Lord.
Because the facts in that case was, and it's actually a case that stemmed from this division in Iceland, where the 204 witness recanted the evidence
Indeed, sir.
on more than one occasion.
If I may proceed, my Lord.
Yes, sir.
With reference
And
to
of course, in Kenya, the court did not grant him.
Indeed, sir. Referring to Taylor at paragraph 43, I quote, paragraph 44, my apologies. In the main trial, the evidence of a witness need not be accepted in totality to carry weight. Frankly and honestly on all questions stand against the tried law that in the decision-making process as to whether or not to accept the evidence of an accomplice who testifies under the auspices of section 204 in the main trial, it is not expected of the accomplice that his testimony is wholly truthful in all he says. His testimony would suffice if it is to a large extent truthful and sufficient corroboration therefore exists. And then in paragraph 45 of Taylor, there is a difference between honestly and frankly and trustworthy. A witness may answer subjectively, honestly and frankly, but may make a mistake. If he made a bona fide mistake, he might not be refused indemnity, but his same evidence must be rejected in the main trial if it is material to the issues. And then finally, in paragraph 46 of Taylor, the test for veracity of the evidence in the main trial against the accused is objective against all the evidence adduced. The test for indemnity is subjective. The witness must testify to the best of his ability in the circumstances that prevailed. Circumstances such as intellectual and emotional intelligence, fear of intimidation, ignorance of the legal system, and many more come to play when an indemnity inquiry is held.
Of course, the court in Kenya merely referred to a few of the circumstances.
Indeed, Sir, my Lord.
And that's not a numerous class.
Indeed, Sir, my Lord. I will also elaborate on that. In this regard, my Lord, it is admitted that the witness was subjected to days-long evidence in chief and rigorous cross-examination for days by each of the three counsels for the defence. All of this while in the unfamiliar environment, at least for the witness, of being in a courtroom, in addition to intense public interest and live media broadcasts. It is submitted that these were extremely stressful circumstances, which can be evidenced by the fact that the witness had to receive medical attention during her testimony. It is only human to expect that the witness, under these circumstances, may make some errors. If I may just pause there for a minute, my Lord, let me also look at the human aspect of this. My Lord, I would, from personal experience, I have come across very few of my learned colleagues in the legal field that has much or any experience being a witness in a witness box. We always stand on this side asking the questions, which I submit is very easy. I have been in a previous career when I was much younger, much thinner and had short hair. I used to be a police officer, and I remember very, very well as a very young police officer going to court to testify for the first time, and how nerve-wracking that was. And it's a very lonely place being in the witness box. And only after many hours in the witness box do you find your feet. And that was never under intense public scrutiny, live TV cameras. So I would just urge, my Lord, that we also do not forget the human element in all of this. Regarding this court's judgment in the main trial, this Honourable Court found corroboration for aspects of the evidence of the witness from various independent sources, in that the court accepted and referred in its judgment to the mind map that was submitted by the state in their heads of argument in this regard. The court did not, from what I heard in the court's judgment, reject the evidence of the witness out of hand, and it would appear that the court, at least in part, relied on aspects of the witness' evidence in reaching its judgment. The court also ruled that it found sufficient corroboration for the reliability of the witness testimony, which was also supported by circumstantial evidence. In conclusion, my Lord, I would therefore submit that, taking all of the above into account, that the witness did in fact testify frankly and honestly, considering all the circumstances. The witness has made huge personal sacrifices in her personal life also, my Lord, considering that she and her children had to be uprooted from their lives and their community and placed into witness protection. I would submit respectfully that the witness has much to lose, because she knows her possible immunity from prosecution will be jeopardized if she was not honest to this court. And I submit this in itself would have incentivized her to be honest. I respectfully submit that the witness did make a case to receive immunity from prosecution in terms of Section 204 of the Act on all the counts as contained in the indictment, as well as all competent verdicts that you know. If there's anything else the court wants to hear me on.
What is the nature of the test? And I'm going to illustrate. You have, in the case of Ms. Lombard, you have the extracurricular statements she made. So that's the first statement of the 20th of February. Then you have the statement that could have been a statement that would be admissible under Section 217. And then you have what became known as the lengthy 204 statement that you worked on. And a lot of the contradictions, if it can be described as such, comes from a comparison between ultimate oral testimony after being cautioned in court and those extracurricular statements. What weight does one attach to that, applying the test as set out in the Act? Because what the Act requires that I determine whether the witness answered all questions posed honestly and frankly.
My Lord, during the process that preceded the witness being called up as a witness, at the stage when she was co-accused, when I first got involved in that, during the interview processes that Captain Lombard, the mitigating officer, had with Ms. Lombard and in my presence, one of the things we did was, what Captain Lombard did was confront the witness with her previous two statements as the court as referred to. And she has indicated during those interviews that at the time when she made those statements, it was fairly close to the whole incident occurring. And at that stage, as a co-accused, she accepted the offer of 1,000 Rand in order for her silence and not to report anything to the police. She labored under that and still under that agreement that they made. And at the stage also, according to my instructions, my Lord, she was also using TIC at the time on an almost daily basis.
Well, we saw Ms. Lombard at the interview she had with the captain. I commented on the change that we saw between that stage and then, of course, in October when your intervention came, and then ultimately at trial.
Indeed, sir, my Lord. At the time when I was involved in the 204 interviews, my Lord, it was mentioned to the witness what about the previous two statements, and her response was, it was close to the incident. There was still this agreement they had that she accepted, but as time went on, conscience got the better of her, and that is when she decided that she was to rather be a state witness and tell the truth. And she was then doing the 204 statement said, She acknowledges that certain things she said in the first two statements were not the truth, but she is now taking the captain and myself into a conference, and she wants to tell the truth of what happened. She never shied away from that, my lord. She admitted that there were some untruths, and that is the reason why. But now I want to be a state witness, and I want to clear my conscience.
Some authors refer to our system of indemnity under Section 204 as being transactional. So it's a deal made, ultimately. And isn't it in the nature of a transactional agreement that it's a process?
My lord, I've also read articles in that vein, that it is almost like a contractual relationship between the state and a potential witness before trial. So there is that.
So you have a participant in crime, and as the Constitutional Court pointed out, this is very effective in organized crime, or when you have multiple participants. You have a participant in the crime that one can expect often and at the outset will shield and not disclose everything. And as time goes on, and there's the potential benefit of non-prosecution, the person opens up more. Do you then hold it against the person at this stage of the inquiry, where the test is different? Because it's not about trustworthiness now.
I would rely on what the court in Canada has said, that the test is subjective regarding the immunity, and if it was in the mind of the witness that she did tell the truth, I would raise my argument with what the court in Canada said, that it's a subjective test, my lord.
Now, more particularly insofar as it relates to Ms. Smith and her involvement, absent the evidence of Ms. Lombard, would the state have been able to successfully prosecute Ms. Smith?
My lord, I'm afraid I would not be in a position to address the Honourable Court on that. I was not party to the trial. I did not have access to
because
the
remember
transcript.
the extracurricular statements of Mr. Van Rijn and Mr. Apollos were not in itself admissible against Ms. Smith. Absent the evidence of Ms. Lombard, I would not have been able to find the agreement that preceded the act. That's the discussion on the 18th. And that was integral to the eventual finding against Ms. Smith.
Indeed, sir, my lord, that I will, and that is why I've also submitted previously during my arguments that from what I heard, what the court said during the verbal judgment is that my submission is that the court must have found some kind of reliance on the testimony, certain parts of the testimonies of Ms. Lombard to make its final ruling. And I would submit with that in mind, my lord, that the testimony of Ms. Lombard then did assist the state and ultimately the court to make a ruling.
And it's only on the charges that I have cautioned her.
Indeed, sir, my lord.
Yes, thank you, Mr. Van Tonder. Do you have a copy of those notes that you prepared?
I have, my lord. I have made some.
Could you provide us with a copy for the record?
I've also made some copies for my learned friends, my lord.
Thank you. Thank you, Mr. Van Tonder. You may be excused.
Thank you, my lord.
And once again, indebted to you for your assistance.
Thank you, my lord.
Ms. Lombard, you have to remain present until I finally have ruled on the issue. Gaan met die Afrikaans praat?
Yes, my lord.
So wees net geduldig. Dit mag dalk nie vandag wees nie. Ons sien hoe die argumente aangaan. Ek vermoed dat het eers môreoggend sal wees. Maar ek wil hê jy moet ook teenwoordig wees wanneer die staat hulle betoog lewer. Want dit gaan ook hier raak. Goed, dankie, kan so. So before we turn to Mr. Harmsen, if we can maybe, I can see we're still a bit tight on seating. Ms. Lombard, can you maybe further to the left? More further to Mr. Zabalila. And at least we will free up 2 more spaces there next to Ms. Ishmael. So any members of the media or anybody else that wants to move in there, you can feel free to do so. Mr. Harmsen.
By this getting to be much earlier than I thought. Your Lordship is in possession of my notice of application for leave to appeal.
Yeah. That's the one that was filed on the 9th of June.
Correct. It's got the Chief Justice
Wait,
stamp.
I'm looking at the wrong one. Your one is the one that is also filed on the 9th. I was looking at the civil rights one. Yes, so you apply for leave to appeal to the full bench, the full court.
Alternatively, in Your Lordship's decision or the Judge President's decision to the Supreme Court of Appeal.
Is there any, this is an appeal on the facts.
Yes.
Is there any reason why in the event that leave to appeal is granted, that it should be granted to the Supreme Court of Appeal?
I can't submit that there are any reason why it should go to the Supreme Court of Appeal. I would and am of the view if in full court hearing this appeal, it will be, although it's the same division, it will be an objective and true observation.
A full court appeal is the 3 judges in the division.
Yes.
And unless there's good reason, either an issue of law or any other compelling reason, then leave to appeal should not be granted to the Supreme Court of Appeal. That's what I'm asking you. Is there anything?
No, I do not submit that there is, and I do not, am not of the view that there would be any reason why it would necessarily go to the Supreme Court of Appeal.
Now, let's start with your application. This is only an application for leave to appeal on the conviction.
Conviction, correct.
Not on the sentence.
Not on the sentence, no. My Lord, unless Your Lordship requires me to do that, I'm not going to read the grounds of the reason for leave to appeal being sought. I'm not going to read it.
It strikes on 2 issues, primarily, as I understand it.
Yes.
The one is the admission of the extracurrial statement.
Correct.
That's Exhibit KK, read with the physical exhibits, the videos. And then, of course, the findings insofar as it relates to Ms. Lombard's evidence as well. It also ties in there.
Yes.
But it's primarily aimed, your appeal is primarily aimed at that, the extracurricular statement.
Indeed, my Lord. My submission is that, and it was argued, although that is now behind us.
Because if the extracurricular statement is admitted, it's properly admitted, it's the end of the line for your client.
Indeed, it was admitted, and this court has found
No, but
that...
if I correctly admitted it would be the end of the line.
Correct.
For both Mr. Apollos and Mr. Van Rijn, on their own versions.
I can only speak for Mr. Apollos. I'm in agreement with you as far as that's concerned.
Now, what was the attack on the admissibility of that statement?
My Lord, as was argued in the trial within a trial, the high water mark of accused number one, Mr. Apollos, is that, and it was also pleaded in his plea, that he was coerced. It wasn't done freely and voluntarily. That test is, in my humble submission, a reasonably stringent test.
No, and the state bears the onus.
Yes, yes, and I'm not going to argue that again. My submission to this court is that this court erred in not finding or not placing sufficient value on the evidence of, I can mention her name again, Sharon, the poor witness on behalf of Mr. Apollos, who worked at the hotel. She went through a hard time. But if I could just leave it there to say, my submission is that there wasn't sufficient emphasis or credibility on her evidence, where she gave evidence how she viewed and saw Mr. Apollos in the hotel the morning before he ended up at Seaboard.
So where did I err?
Or the afternoon, actually, sorry.
Where did I err in the respect of her evidence?
Well, my Lord, my submission about erring is I deduce from...
I'm approaching it with an open mind.
Yes, I understand.
That
Yes.
when one deals with an application for leave to appeal, that we can make mistakes, we can err.
Yes.
But show me, on the record or on the judgment, where did I err?
My Lord, I cannot...
Because a lot of allegations are made in some of these applications before me.
I cannot
that we will
refer
get
your
to
lordship
later.
I cannot refer your lordship to a specific sentence, but in overall what has transpired from the judgment and from the finding in the trial within the trial. The court found that, and the court could only have found that the executorial statement was admissible if it was not coerced or unreasonably, or that his constitutional rights were not infringed. And my submission is that a very important part of that is the injuries that Mr. Apollos has shown. There was evidence from the state. A lot of the state's witnesses came and said, yes, we saw the left eye was blue, and significantly blue. And we saw on Exhibit KK, in the video, that he was limping. So my submission is that, and also if one has a look at Exhibit MM of Sergeant Foutain, which saw him the next day, the 6th of March, also noted injuries. And there was, and there is no evidence that Mr. Apollos, from the time that he left the hotel and got to Wikisby, to Seaborder, sustained any injuries. And that cannot be a mere, maybe it's possible. He could have fallen. That is not sufficient, my lord. If there isn't substantial or sufficient evidence which points to the fact that it is more than reasonably true that Mr. Wallace could have and did sustain injuries between the hotel and Wikis Bay, it must be accepted by this court that he didn't have any injuries until he was injured at sea border. Now, both Sergeant Fontaine, Captain Lombard, initially very specifically made a point in their evidence of referring to these injuries, especially his eye. Now, there was an independent witness who came and said, I saw him, I don't know, he had no injuries. And it was, and I don't want to deal with all the evidence again, the state then made the assumption that the witness couldn't have seen him properly. But the witness did give evidence and say, I was at the reception desk, he walked past me, in front of me, from the right to the left, I could clearly see his left eye, there was nothing wrong, and he wasn't looking. My submission is, if that is true, if that is accepted by the court, if sufficient value is placed on that evidence, then it should be concluded that he arrived at sea border without injuries. He was collected by the police, transported directly to sea border, and there he got out, and there he saw at least Captain Lombard, which immediately said, I saw a blue eye.
How does the court evaluate evidence? Do you look at it piecemeal, or do you look at it holistically?
No, not piecemeal, my lord. Yes, one has to look at it holistically. But
so, that was not the only evidence, was it?
well,
I'm merely referring
yes.
to the inquiry about admissibility.
No, that is not all. But that is the main issue. Is did Mr. Wallace have injuries? Did he sustain injuries? Yes, he did. It's there. It's documented. Evidence was given about it. Captain Lombard, Sergeant Fontaine. But the state's case was, the evidence was, that this was sustained previously, prior to arriving at sea border. And there is no evidence to that effect, my lord. In contrary to that, the evidence that's before the court is that he had no injuries at the hotel, and it is unlikely that he sustained injuries from there in the presence of the police going to sea border. Where would he have sustained the injuries? That leaves us with the question, but when did he sustain the injuries? Certainly not before he got to sea border. Now we're sitting with Exhibit KK. What the accused, Mr. Wallace, gave evidence about. Yes, he was not a good witness.
That's putting it lightly.
Very lightly. Yes, he wasn't a good witness. He double talked. He changed his evidence. True, but it doesn't take away from the concrete, objective evidence that he had injuries. And I submit that this,
and then he made
if it's reasonably possible,
and then he made up
true,
a story about what he put on the content.
Mr. Wallace's reasons which he gave, he also said why he gave the reasons why he sustained injuries.
Did the injuries play any role in him making up the content?
Well, that is what Mr. Wallace said, yes. That was his evidence. Now, I understand that this court has found that he is not a credible witness, but
you're not attacking that.
That is not the...
You're not attacking my credibility finding.
No, I'm not attacking that one. But I
would have been surprised.
I am saying...
I wouldn't be surprised because I've seen other attacks in some of his applications earlier today.
Yeah.
But you will agree that the state it intends to produce the evidence of the extracurricular statements. There's a debate at the time. Does it amount to a confession, or are they merely admissions? I now hear that the court has to pronounce on that midstream. First time I hear something like that. Be that as it may. And then the state presents the evidence, whole conspectus of from point A to point B. Then the accused changed his attack on the admissibility. Then he did tell the police that, then he didn't tell the police that. Then when it comes to the injuries, he gets taken to the doctor, keeps the doctor version. We see him on video, talks about whatever he talks about. And I'm just taking snippets here and there, because if you take everything holistically.
I will get back to the holistic evaluation of all the evidence when I get to...
and I don't want to repeat all of it. That's not the exercise here.
No. I have another argument, but just on the admissibility of the executorial statement by Mr. Pollis. If, as the Lordship says correctly, one has to approach this holistically, look at all the other evidence. It cannot be disregarded, and if it is, I would question why was the evidence of the witness on behalf of Pollis, who said he had no injuries. No, we have to accept, because there are no grounds, or there is no evidence other than mere speculation or suggestion from the state that Mr. Pollis had the injuries when he arrived at Seaborder. And that's just in the air. Now, my submission is, if it's reasonably possibly true, that's what he did have injuries. And there is nothing that indicates how or when he sustained those injuries. The doctors reported it was a fresh injury. It wasn't a day or two before, 3 days before. If it was so, it would have had the injury in the hotel when he walked past the receptionist who saw him. No limping, no blue eye. My submission is then, on those facts alone, it's in direct contradiction to what the state says. That doesn't amount to beyond reasonable doubt finding that he wasn't injured when he was interviewed. It can, my lord, with respect. I certainly don't want to go through the evidence again, but if one has a look at Sergeant Fortuyn's notes on the injuries that Mr. Pollis displayed after he's been to the doctor, after the doctor has assessed him, and my humble submission, the doctor's assessment was blasé on top. What Sergeant Fortuyn noted was much more than was written down on the J88. Now, if the state's witnesses are credible, and especially when it's in this instance, then it should be accepted. What Sergeant Fortuyn noted on Mr. Pollis when he took his warning statement on I think it was the 5th or the 6th. The 6th, I think it was the 6th. At light black, yes. There's no reason why that should be ignored. He had those injuries, and he certainly didn't receive it from Seaborder to when he arrived at light black. He was on a police in police custody. He was transported there in that same polo he was sitting at Seaborder. My submission is then, those injuries cannot be wished away. It is there. If there is no explanation from the state, a reasonable explanation from the state, more than reasonable explanation, that can lead this court to a finding that beyond reasonable doubt he had sustained those injuries before his interview. Then the evidence in his executorial statements and in the trial should be disregarded. It's not admissible. If I may move on to my second point. On the concept of holistic, considering evidence. I'm not attacking, and I cannot. I do not. I state that categorically. This court has made a finding. They are convicted. They were convicted. Mr. Pollis was convicted. But I want to just point to two aspects. The state's case, and at the end of this, my submission is that a different court would, and I'll get to the test, if I may, later, for leave to appeal. The state's evidence started off with Ms. Lombard, the 204 witness. Now I'm arguing, as I suppose another court on this point alone might agree with me, that there's a 204 witness, she was present, she gave evidence, and there was an event that took place on the 18th of February 2024. And that event, my lord, was that Joshlin was taken from accused 3 and 1's house to a polo. Your Lordship will recall there it was. That's the one event. The 204 witness gave evidence. She heard discussion of which Mr. Pollis, his attitude was, I don't want anything to do with this. He distantiated himself from it. He didn't accompany accused 3 with Joshlin to the polo. He didn't agree to it. He distantiated himself. That is an event, my lord, that took place. This court, in my reading or viewing of the court's judgment, the court accepted that event as had happened. That's what happened. That's what was given evidence about, and that happened. That's my understanding. On that basis, if that was the only evidence, my lord, then accused number 1, Mr. Pollis, about him, it could not have been found by the court that he was complicit to it, that he supported that he helped and agreed with this event of taking Joshlin to a car which the evidence said was where Sangoma was. He had nothing to do with that. He distantiated himself from that. Well, that is the evidence that the state presented initially. Unfortunately for the state, the 204 witness was not a good witness. This is my submission. And then after that came the confessions, the so-called confessions, and the trial within a trial, of which I've addressed the court now already on. that evidence was adjudicated admissible, was found to be admissible, and it was admitted. On that event, my lord, and I submit that is the second event, Joshlin was taken by Mr. Apollos, accused 1, to Makalima's house on that evidence, which was admitted. Now, my lord, there are two questions now. The first question I would ask, if that was so, and this court found it, in my humble understanding of the judgment, that is what happened, because that is being held against accused 1. If that is so, why did Makalima go? Why was she released? If that is a fact that happened, that Joshlin was taken to that house and nobody saw her then again after that. She can't disappear in thin air. There's no explanation from the state what happened to Joshlin. She was there at the house. The evidence was accepted by the court. Now, the difficulty that I'm sitting with, my lord, but I submit with respect a different court more than would probably, would reasonably come to a different conclusion is that when there's a crime, my lord, if I may say this with respect, when there's a crime, there's a victim and there's a perpetrator, there's an accused. Now, if I may use the example of somebody having been killed. Now, there's evidence that this victim was shot, and there's evidence that this victim was stabbed.
No, Mr. I don't want to cut you short. Where do I find this ground that you're arguing now in your application for leave to appeal? In the notice that was filed?
I will just have a look at it.
Under what paragraph does it fall in the notice? Remember, you have to set out in terms of the Act the grounds upon which you seek leave.
Yes,
where in this document of the 9th of June do I find the grounds upon which you now want to argue?
Yes, my lord, I see. It's not in my. It's not
on
in.
what basis are you offering me argument that you've not sought leave to argue? Remember, we're not re-arguing this case. We are strictly bound by the Act and the rules, and you can only argue points that you've raised in your notice.
Then I will step off that point.
Yes.
Then, if I may just very briefly.
So in terms of which section of the Superior Courts Act do you want me to grant leave?
It's the new Act.
Because it's not mentioned. It's not mentioned in the notice.
No, it's not.
But in terms of which section, because it's a point of law, so I will allow you to go beyond your notice for now.
Superior Court Act 10 of 2013.
Yeah, but which section of the Act?
Section 17, 1A, 1 and 2.
Only on those two. Remember, section 17 has, in 1 it has 3 subsections, and under A it has 2 subsections.
Yes, it's 17.1A, 1 and 2. If I may, just for the sake of completeness.
No, I actually have it open in front of me. Now, he will admit that the law has changed in how the test is applied.
Yes, this is the new Act.
In 2013.
Yes.
when this act was promulgated.
Yes.
So the act now reads that leave to appeal may only be given if certain conditions are met.
The one I'm reading here, my lord, is 17(1)A of Act 10 of 2013, which says leave to appeal may only be given when the judge or judges concerned are of the opinion that A1, the appeal would have reasonable prospects of success.
So that's the point you argued on the basis of the extracurrial statement. And that's the only point you've taken on the notice.
It is. It is.
Because we already determined earlier on there's no compelling reason.
Okay, that's the only point.
That's the only point.
And if, on that point, I may refer your lordship to the first matter, which is a Gauteng Division, High Court of South Africa, Gauteng Division.
Of course, I asked the parties in the week to provide me with the cases you're going to refer to.
But I didn't get that correspondence. I saw the correspondence regarding the 204.
It was under the same email. But you can mention the case, I will find it. I have my electronic library available to me here.
The matter that I'm going to refer to, that I wanted to refer to now, refers to a Supreme Court of Appeal, S versus Smith. The lordship might be aware of S versus Smith, which is 2012 SACR 567 decision.
Yeah, what about that?
And I'm very aware that there are arguments as to, and it is stated whether the test is now higher or not higher for granting leave to appeal. I submit that the new Act didn't change what the Supreme Court of Appeal had said in S versus Smith at paragraph 7.
In fact, there are authorities to the effect that the test has changed.
There's another matter, the Supreme Court of Appeal, unfortunately this is a matter that took place in 2011.
Refer me to cases, and there's a whole string of them after Section 17 was promulgated.
Yes, my lord. The matter that I was referring to now, the Gauteng matter, is a 2023 matter.
Yeah, Smith.
No, the Gauteng matter is Kumalo in Kobile.
Give me an opportunity.
Case SS.
Give me an opportunity to open, because you didn't favor me with.
That's a judgment by Duplessis AJ.
So it's S versus Smith. S versus.
It's the state's respondent, Kumalo, Khumalo.
Wait.
Versus the state, Kumalo and another.
Now I don't know why you say you didn't get the email. I specifically, and I saw the email because I said I must be copied in, because I specifically said copy in all the parties, because the previous email you would have seen was an email when I opened the string. That was in dealing with Mr. Van Tonder, trying to get him here.
Maybe that is the misunderstanding.
So you didn't read the email, and now you want me to
I read the
follow
email.
as you're reading. But
I
that's
read the
fine.
email.
So it's Kumalo and Mother versus
The state. High Court, Gauteng Division, Johannesburg, SS8/2023.
I can get it on Safri, but So that's SS 8 of 2023.
In that matter, it's
No,
referred-
that's the case you want to refer to.
yes, that's the matter.
SS 8 of 2023.
Yes. In that matter, in paragraph 12, it's referred to S. Smith.
Just one moment. I set up my laptop here and didn't synchronize my mouse, so that's fine. Paragraph
12.
12. Are you saying, are you still going on with saying that it didn't change?
No, I didn't say it didn't change, my lord. I'm stating that I read a matter and I can't put my hand on it now. Let me just get...
In fact, if you look at paragraph 11, the acting judge that wrote this judgment refers to those judgments that we found in footnote 5, it seems. Let's see what footnote 5 says. Yeah, there refers to the 2016 Supreme Court of Appeal decision. Just above the one that you're referring me to, the judge mentions about the change in the test since the Act became operational, and he puts a footnote, and he refers to NEC for Health Eastern Cape versus Kita, which is the 2016 Supreme Court of Appeal decision.
The arguments, my lord, for the finding in that matter is that it could have changed. The test is changed from might to main. My lord, I can also refer to Lordship to Tower Vesta and the state. That's a well-known case.
It's an unreported decision.
It is not reported.
Is it on Safely?
Yes, it's on Saturday.
Because then I can find it. And you'll also see this on a side note in paragraph 13.
Of which matter we now
Of the one that you referred me to. The one
Counting
that you
matter.
didn't tell me before.
Cutting matter.
Kumalo. There that acting judge refers to Ngubane.
Yes.
That deals with the holistic approach.
Yes, the other
Coincidentally, I didn't read the judgment because you didn't tell me before. Otherwise, I would have read it. But counsel think they can surprise you.
No, my lord, not my intention.
No, because I gave you the heads up, all of you,
Yeah.
so that I can prepare myself. Because the history in this case is that I've been confronted with cases totally out of context.
My lord, my submission in this matter, in this application today, is that it is not a complicated matter. The grounds for leave to appeal to be granted is clear. If I may, and I haven't again referred your lordship to Talo Vesta, but Talo Vesta versus the state in paragraph 4. By Judge President JP Dafu J.
There's no day. There was never a Dafu JP.
No, sorry, not J. JP is the initials now. JP Dafu J. Judge. That is a matter, sorry, it's not in the Supreme Court of Appeal, it's in the Free State Division of Bloemfontein.
The Tabo Bester case.
Was in Bloemfontein.
Wait. case number?
Case number 83/2023.
I'm checking on Safely whether it's there. That's a leave to appeal judgment
Correct.
on the 29th of April 2025. Is that
Correct.
the one you're referring to?
It was heard on the 23rd of April this year.
Let me open it. Yes.
If I may
See,
refer
he's
to
referring to
paragraph
both.
4.
I see it's referring to both Smith and the MEC
Yes.
versus Nikita.
But as we've seen now, my Lord, Smith was a 2012 matter. I'm not sure when the...
I know Nikita was 2016, I told you.
But if I may refer to paragraph 4 of this downward estimator, where it says later on in MEC for Health, Eastern Campus, Nikita and another, the SCA repeated the principle in the following words. Once again, it is necessary to say that leave to appeal, comma, especially to this court, comma, must not be granted unless there truly is a reasonable prospect of success. And then it refers to section 17(1)(a).
Yeah.
And that leave to appeal may only be given where the judge considers an opinion that the appeal would have a reasonable prospect of success. And that's all we are. I submit.
So your discretion is limited to an extent by the new wording.
In other words, my submission with the facts that we are confronted with in this matter.
You see, the old test was that the appellant or the applicant at that stage must convince the court on proper grounds as set out,
Yes.
not thumbs up whilst you're on the feet in court. That there are prospects of success in the field. And then we'll talk about realistic chances of succeeding and now the dictum that you quoted, and I've had not the opportunity to look at the whole case, but just on the dictum that you quoted, the appeal court says, in dealing with particularly appeals to the SCA, that it must not be granted unless there truly is a reasonable prospect of success.
Indeed, I'm in agreement with that.
Not a realistic chance, just truly. And but that's in the opinion of the trial court.
Yes. Yes. Now I'm getting back to my submissions. And although in my notice of appeal I didn't refer to the two events that we had, my submission is if another court views the evidence that was led in this matter regarding the trial within a trial, that there is more than reasonable, there is a truly reasonable chance that a different court will come to a different conclusion regarding the admissibility of the evidence. And then I am allowed, if I may submit that with respect, to take that argument further. If that is so, well, then I submit that this court should take that into consideration. If another court comes to a different conclusion as to the admissibility of the extracurricular statements by Mr. Apollos, accused number 1, that would get rid of the Makalima story. as far as accused number 1 is concerned. Then we are left with only one event that evidence is before the court to be considered. And that's the one where Joshlin was taken to the coroner. And there, Mr. Apollos distantiated himself from. So my submission in short, my Lord, then is I think it's truly a reasonable prospect of success. That a different court may find that the evidence that was admitted regarding the executorial statement should actually have been inadmissible.
Thank you.
Thank you.
Please think about it.
Thank you, Madam.
Mr. Adams said that for your information, seeing that you didn't read the email, it was sent on the 7th of August 2025 at 11:57.
My Lord, I did agree that I did receive an email, but maybe then I did misread it because I saw it as pertaining to 204, Mr.
And
Thornton.
it says, while heads of argument are not requirement parties, plural, are welcome to submit them should they wish to do so. Should you intend to refer to any legal authorities, kindly ensure that these are submitted in advance to allow Judge Erasmus sufficient time to peruse them.
My apologies, my Lord, if I misread it.
And yes, it could have been structured differently by not CCing people but sending it to them directly. It's clear. It refers to all parties.
I took it as having bearing on Mr. Van Tonder only, my Lord. I apologize.
But you also know, Mr. Harrison, that I want to know beforehand so that I can prepare myself.
Yes.
But I'm happy to be surprised. Thank you.
Thank you.
Morning, my Lord.
Morning, Mr. Kabai. Let's get your application.
I'm open to sports directive. Whether to start responding to 204 application.
The applicants have no role to play in that application, but you may comment on it if you wish. But the applicants have no role to play. The only role players in the 204 application will be the court that ultimately has to make the decision, the witness, and the state. And that's how I understand the authorities to be. And prior to it being clearly stated in the judgment of Kayla, which judged the process I agree with, except there may be an argument as to which stage of the proceedings the court deals with it, that the accused persons in a trial plays no role in that determination. But, as I've said, if you have anything to add and it may assist me in coming to a conclusion, I'll be indebted to you for that.
Thank you, my Lord. I had something to say regarding the application for 204 discharge.
Before we proceed, Mr. Kabai, as you know, I don't take breaks. So if any of the parties wish to take a break, just alert me. Because I've noticed on my watch, it's now the customary short adjournment. But to me, it doesn't make sense to take a 15-minute adjournment. But if you want to take the adjournment and take a 15-minute break, I will oblige. Do you want the adjournment, Mr. Kabai?
Yes, I will.
Before you start? Good, so we're going to take the adjournment till 11:30. Can I just, the stenographer, I do not take customary lunch break, but you can just arrange between the two of you and the light is on. It's unlike as in Saldana here, we can record remotely, so we don't necessarily need a stenography in court. Quarter of an hour adjournment, please look in.
All right.
criminal duties in Kaina, they're totally different to what took place in this matter. Number one, in Kaina, my lord, there was a ruling. A ruling regarding the test, threshold test, whether the 204 has answered the questions frankly and honestly. And this ruling and the inquiry took place after the judgment. In this matter, my lord, the ruling, the inquiry will be taking place 6 months, 3 months after the sentence has passed already.
So what?
That's where I'm going. That's where exactly I'm going, my lord. I will, to that question, I will refer to paragraph 2. Tyler, that question is being answered. What will happen now to the evidence? Yes, I marked it just now. Why now I don't see it?
Paragraph 52.
I marked it. No.
You're talking about when it takes place. She comments in 52 in a short paragraph.
It's 45, my lord.
45.
45, yes.
Yeah,
The
what about
witness may answer subjectively, honestly, and frankly, but may make a mistake. If he made a bona fide mistake, he might not be refused indemnity, but his same evidence must be rejected in the main trial. How do we do that? Accused persons have been already convicted and sentenced.
No. This whole issue in the judgment of Kayla, judgment by Lani Opperman, judge. And it's the first judgment that deals with it extensively, separating the different stages, and she describes the 3 stages of the inquiry, of the process of 204. So that's pre-evidence, evidence, and then this inquiry. 45 is part of a section where she discusses the test to be applied. And that starts from paragraph 40 of that judgment. Then she goes on and particularly in 40, from 43 onwards, she says, the 2 processes are irrelevant to each other. In the indemnity inquiry, you do not require, and I'm paraphrasing what she said, the witness to convince the presiding officer that the evaluation of their evidence in the main trial was erroneous. It is to convince him, she uses him, that his evidence was frank and honest and a completely different platform. The test to be applied is different, and then she comes to the test and then deals with the under 45. The way I understand 45 is that even though the court would not rely on that evidence or would have found the evidence to be reliable and trustworthy, that witness might still be granted indemnity because of the difference of the test. When the evidence in the main trial to establish the guilt or innocence of the accused, the test is beyond a reasonable doubt. When it's for the indemnity inquiry, it is on a balance of probabilities. And you are limited to the grounds as set out in the section. And then she goes on, the portion that Mr. Harmse quoted, where the court in Kayla refers to personal and intellectual and emotional challenges, etc., etc., etc. Now that comes from a far longer list that was set out in other cases and in more academic writings, because there's not a lot of cases breaking it up. She also refers to over and above the Muhammad case, where Howard, JP, and Wilson gave that judgment, and also refers to the later judgment on the evaluation of the evidence in Zawande of KZN, which is not that relevant to our inquiry here. That's how I understand the judgment. So you would have realized that in the latest update in the TOEI, I don't know whether he wrote that part in the TOEI, in the loose leaf, the publication, actually analyzes the judgment of Kayla. And some of these portions are also quoted in the Makala matter, in the judgment of Chikijay, and also in the minority judgment of Bulchitz. He also refers to the issues in Kayla, because remember, the Makala it's actually known in this division as the Waka case.
Mawanda Makala.
Yeah, but the second accused, that was the name that was how the case was known here in the division. Because there it was different, and it doesn't strictly deal with the indemnity issue. Because there the state declared the witness, the brother, a hostile witness, because he recanted. And you recall how it comes from the judgment of Unterhalter Ormenkumi in the SCA, where they quote the process and the adjournments in between. And I think Mr. Haynes was the prosecutor in that matter. Mr. Menigo argued the case before the Constitutional Court. So it's different, but you must remember when the full bench, because there were two judges in Muhammad dealt with it, they never described this two-pronged approach after the warning. And there was a practice for many years, and it still persists, I believe, that at different stages of the proceedings, courts would pronounce on the indemnity. I've actually seen in cases where courts would pronounce immediately after the witness has testified. I believe it's wrong.
It is wrong.
I believe that one should look at the totality of the evidence and then make the determination. But also, how do you fit in the independent inquiry as to the indemnity of the witness, because the witness's rights are affected and they're entitled to a fair trial. do not stop there, go there. But then you've already made a finding, and that might change because other evidence might come. You have to deal with it holistically. I'm not saying, and I will not say in my judgment tomorrow or later this afternoon, that it must be at a particular stage, but definitely not before the judgment on the merits. But it's up to the trial court to determine how long after the judgment on the merits.
Before sentence, at least.
That you can argue that. It's not your client's case, but I'll hear you on it because it might be interesting. And Opperman J in the Taylor matter does not say it must be before sentence. Circumstances, to my mind, prima facie, might be different from case to case. And the reason I'm saying that is because both the state and the defense has the right to lead evidence on sentence. And anything might come up there. And particularly in cases on the face of it where the accused did not testify in the main trial. I would be cautious, as I was in this case, and I may be criticized for it, that's up to the debate, would wait until after sentence. There might also be instances, like in this case, where in order to give the witness a fair hearing, you need to arrange legal representation for the witness. Might also be, in this case, absent the legal representation issue, where you either give judgment in the circumstances that we set, and then you want to adjourn immediately and stop the proceedings for that day, let the dust settle, and then day on sentence, let the dust settle. You can't go back into court, especially in a setting where we are. So, and I'm not saying that that's the reason in this case, but there are many, many factors that play a role. As long as the court, to my mind, realize that you have an obligation to pronounce on that at some stage, rather sooner than later.
The legislation regarding Section 4 has to be revisited.
You see,
it's not clear and it's risky, especially to the accused person.
So, on my reading, that was a lacuna for many, many years. So in 1753, I think it was, there was an issue where the Lord Chancellor in the UK was charged with corruption. And that was the first time that I could find a country had legislated. So they passed a special law to provide for the other lords to come forward and spill the beans and get indemnity. And then of course there was the development in the US, especially around RICA. But it's been a long issue. In fact, the article that I've spoken to Mr. Harmsler about, the author in that article specifically say exactly what you say, that we need to revisit and to be more clear in regulating the process and at least find definitions for certain terms so that one does not have to go to the ordinary dictionary definition that might be limited in interpreting this part of the statute. But I take your point. I've given you a whole long spiel because I found it very interesting in doing my research on this issue. I'm with you.
Thank you, my lord. I brought an application before this court for leave to appeal. I humbly submit that the prospects of success, they are high, strong, and reasonable. The miscarriage of justice in this matter started as early as before 31st of January 2025. Why I'm saying this? We appeared before court on that day, barehanded.
31st of January was that the appearance before Sally J
Yes.
in the pre-trial.
Yes, my lord. We appeared before that court barehanded and clueless. We didn't have the contents of the document, but the matter was set down for the pre-trial conference. My submission on that is that the pre-trial proceedings were rendered a formality devoid of substance, and that this irregularity is not merely procedural, but goes to the heart of the trial's fairness. This matter was transferred from Frederick Magistrate Court as early as the 21st of October 2024. The state knew about the pre-trial conference. They were liaising with the legal aid officers. They knew who the attorneys will be and our details. We were never finished with the contents of the dockets prior to the pre-trial conference. As if that was not enough, my lord, when we arrived in court on the 31st of January 2025, my client, Mr. Van Rijn, was not brought before court. This failure delayed the invocation of vital procedural rights and cast a shadow of the lawfulness of the appellant's appearance in court thereafter. They were told already on the 21st of October 2024 in Frederick that their matter is transferred to High Court for pre-trial conference.
I'm listening.
As if that was not enough, we were burdened by the state to climb this mountain to go and fetch the contents of the docket, as if it was our fault that we were not finished with the contents of the docket. Is it constitutionally permissible for the state to shift the burden of disclosure onto the defense by requiring them to travel to the NPA offices to obtain docket contents? Disclosure is an affirmative duty of the prosecution. It is not the responsibility of the defense to fetch the information necessary to conduct a meaningful defense. We didn't climb this mountain once. We climbed it more than once. The state's failure to deliver or properly serve disclosure requiring the defense to go to the NPA offices frustrated the right to access information and made the legal process unnecessarily burdensome. This created a power imbalance that compromised the integrity of the adversarial process. The requirement to self-procure disclosure from the NPA reflects an administrative dereliction that undermines equality of arms. They are shifting the onus. It is their duty to furnish the defense with the contents of the docket. When did we receive the disclosure in this matter, Your Worship? We received the disclosure of the contents of the dockets 2 weeks on the second week of February. Second week of February. When was the matter scheduled to start as a trial? The matter was scheduled to start as a trial on the 3rd of March 2025. We only had not more than 2 weeks to peruse, to read the contents of the document. Pages that were close to 1,000, to listen to the reports, to the videos that were not even open. We have to consult with our clients. We have to check whether they do have witnesses. We have to strategize our defense within a period of 2 weeks. A court, differently advised, may well conclude that the irregularity was so serious that it rendered the trial unfair, thereby justifying appellate intervention. It is so important to consult. Your Worship, here we're dealing with a serious matter: human trafficking, kidnapping. 2 weeks can never be enough. Even the best counsel in the world, 2 weeks can never be enough. You read the contents of the docket, you have to consult, you have to check whether you do have witnesses, you have to prepare and strategize your defense. That's what happened in this matter. We perused the contents of the dockets that were downloaded in our USBs at the offices of the NPA when we started the trial, only to discover that even that discovery was not complete, was not full. What does the law say? The law says before the trial starts, the defense has to be furnished with the full and complete disclosure. Full and complete disclosure. We are in Saldanha.
Just a moment. I see doors being opened and people running around. I've been told there's a problem with the ventilation, according to some staff members. So they will intermittently open that door. But that's also the door to our pro bono office. So, but fortunately there's nobody in there today. So I know the aircon is working. But if the parties have a problem, just alert us and I'll see whether we can open some of the doors. Yes, thank you. I'm sorry for the interruption, Mr. Kabay. Mr. Kabay, whilst you're collecting your thoughts on it, now I understand this is a legal point, so although it's not included in the notice, it's a point of law. Hence, I've allowed you to argue it. But can it be raised at this stage, or should it have been raised at the trial stage?
Your Worship, the issue of disclosure, we've been raising it. I remember the other day, I was so...
No, I don't want to interrupt you. I know it's been mentioned. Was it raised as a point that would undermine the right to a fair trial? Because if it is raised, the court must deal with it. If it's raised as a special plea that can be read into 106, 108 of the criminal procedure actually says a court must deal with it. If it's raised through the course of the trial, the court can deal with it as an interlocutory and make that finding. It's now many years ago, in a lengthy trial in this very same courtroom, the issue of discovery of a document in a criminal matter. And insufficient discovery was raised, but it was linked to other issues of fair trial as well, including legal professional privilege. We actually had a trial within a trial, and I ruled, and I said the trial can't be fair. And I acquitted the accused. But this was never raised at the trial as a point for me to determine whether the fair trial rights of the accused were infringed. I'm raising it with you in the context. You would be aware there are many judgments, and there's a recent Constitutional Court judgment that frown upon points being taken on appeal where the Court of Appeal does not have the benefit of the judgment of the court unquote on that point after evaluating all the available evidence before it. Because it means that if a Court of Appeal on a matter that's not been ventilated in the trial court will sit as a court of first instance. And that's not how our system works. But if it's merely raised as a legal point, there must be a factual basis, either on undisputed facts or facts that was found. And that's my difficulty with determining whether I should grant leave on this point. That's the first point raised.
It was raised as an objection to the continuity of the piecemeal disclosure. It was not raised as a formal application, as the court states, but in the record, it is there. It was raised in objection of the piecemeal disclosure, not once, if I can remember correctly. But I will leave that in the hands of the court.
Yes.
My client, Your Worship, my Lord, I'm sorry, was arrested.
Listen, Kabay, I just on a lighter note, when people appear regularly in the lower courts, it comes natural. But speaking for myself, and this might be controversial, I have no preference. In fact, I would prefer that if we can move away from this, my lord and my lady, and find another appropriate way of addressing each other in the courts. Because it doesn't make sense to me. In the Constitutional Court and in the Supreme Court of Appeal, everybody is just addressed as justice. Finish and cloud. So I can't change the protocols by myself, but when you appear in my court, I don't mind if we make mistakes. Let's just brush it over, carry on, and we deal with the issues. I think you've now learned to know a little bit. We've learned to know a little bit more of each other because we spent at least 2 months on trial together.
My Lord, the following ground carries a strong prospect of success in this application of leave to appeal. Warrantless arrest. I mentioned this during the trial, that my client was arrested at about 2 p.m. on the 4th of March. And the arresting officers who arrested him, they didn't arm themselves with a warrant of arrest. To make this ground even more compelling as a ground for leave to appeal is the omission by the state not to call those arresting officers who arrested my client to come and testify before this court why, number one, they arrested my client, why they arrested him without a warrant.
Are we not talking about that came from the trial within a trial, the alleged abduction from the circle and going to Jacob's Spy?
Yes, my Lord. In the true sense of the events in this case, those are the real arresting officers. Sergeant Joshlin?
That's, of course, if there's any factual basis laid for it, but you know how your client had difficulty in explaining that. It turned out that he had to use the helicopter on the route he described. And of course the state's evidence that was undisputed in the main trial had nothing to do with that arrest as described in the trial within the trial. The accused never testified. So where's the factual basis for that? And does it mean, as a matter of principle, that if an arrest is unlawful, that the fair trial rights are infringed?
My Lord?
More particularly, an arrest without a warrant, where a warrant was required, so it doesn't fall within those exceptions. I think it's section 40, round about there in the Criminal Procedure Act. Does it follow as a matter of principle?
My Lord, my client didn't struggle to explain what took place.
It did not testify in the main trial.
Yes.
Period.
Yes, my Lord. He did not testify in the main trial. These are the facts. And these facts...
I hear you, that's what you're saying.
They were not disputed, my Lord.
I can only rule, or any court can only rule on evidence given under oath. Unless I've been asleep, accused number 2, your client, never testified in the main trial. Testified in the trial within a trial. And we all know that the evidence given in the trial within a trial, where we determine the admissibility of the accused, cannot be used in the main trial. Because it's isolated, that's a choice he made. But in any event, I see you take issue with a comment I made in the judgment. He was such a bad witness on the description in the trial within the trial. It was not surprising to me that he wasn't going to take the risk of getting into the witness stand again. Might have been cross-examined by a different prosecutor, that of the two, but maybe the effect would have been the same. He would have suspected, I think.
I will come to that ground, my lord.
Now there are many grounds. We're still going to debate a lot on the grounds that you've set out. I found it amusing to see that these type of grounds are raised, because I was very tempted to say, let me grant leave. Let the Court of Appeal look at all the videos and see whether Mr. Kabai is on point with the allegations made. But obviously you take instructions from your client. The client believes I bullied him, so be that as it may.
As far as the video evidence is concerned, I was in court. I watched the video.
No, I'm talking about all these people with their cameras, the big cameras. That's not part of the official court record. But if any of those grounds have any substance, then maybe you should ask that the Court of Appeal actually watch the proceedings and see how I bullied you and the accused. I'm not going to defend myself. And I will grant you leave if there are grounds. By all means, but if you have no grounds, this matter will end when we end here today or tomorrow.
My lord?
And I'm going to sleep on it, I can promise you. I won't give it this afternoon.
Following is another ground. They term this process an interview. The police, they term it interview, and the state, they term it interview. We call it police brutality. An interview that was never recorded. The questions from the interviewer, the alleged interviewer.
We're now talking about sea border.
Who are at sea border.
Yeah. So that interview, distinct from your client's case, Captain Siakui.
No, not that one,
It's not
my lord.
Siakui. It's not Siakui. I saw in your documents.
Captain Siakui, my lord, is not involved in police brutality.
No.
He is
That's what I'm
involved
saying. We
in the
limit
confession.
the thing that they call an interview. We're now speaking about sea border. They say it's an interview. You say that's police brutality.
Yes.
I just want to place us so that I can orientate myself.
They are alleging that it was an interview, but they fail to prove the said interview. The record of the interview, the record of the questions, the record of the answers from a client. How can that be an interview? It is not private. But the injuries that my client alleges that he sustained and suffered resulting from police brutality were confirmed by not only one doctor, by two doctors. The first doctor didn't rule out that the injury sustained by my client resulted from the torture. Even the second doctor didn't rule out that the injuries sustained by my client resulted from the torture. Why then did Captain Sikri proceed to take a confession from a person who had injuries, and these injuries are medical recorded. It is my humble submission, my Lord, that starting from Jacob's Bay, I forgot to mention that part of Jacob's Bay, where my client's private parts were pinched, where a firearm was forced inside his mouth, where he was threatened to be drowned in the ocean, where he was threatened to be buried in the sand. My humble submission is any statement that can come from a person who's been tortured in that manner in law is inadmissible. A bleeding man has no will.
Timothy?
Another ground for our application for leave to appeal is the fact that during the said interview, before the interview started, the policemen who were there, they never explained to my client his constitutional rights. The right to remain silent, the right not to implicate himself, the right to entertain was never one of those rights.
Of course, they say he wasn't arrested by that time.
That's where we differ. At that time, he was arrested.
You know, I know you differ, but where's the evidence?
The evidence is this is the evidence.
Where is the
On
evidence?
the
record?
It's on the
Because
record, my lord.
Remember, your client didn't testify.
On the
When we deal with a trial within a trial, all of that was taken into account because it turned on the admissibility of the ultimate statement that was made to and recorded by Captain Seaqueen. If that falls, that evidence stands. Now there I had to make a credibility finding. Now, I know that you believe your client. You've got all the right to do that. But I think you're one of the few people that will be believing on what we've seen and heard in court. Because he was an absolutely bad witness. You criticize Ms. Lombard. I don't know why you're not criticizing Mr. Van Rijn. Of course you're representing him. And I had to make a credibility finding. So I found that he was untruthful in what he said, what led up to. And that coupled with the real evidence. Not he said, she said. The digitally recorded evidence on visuals. And then of course it turned out this man that was asleep could speak nicely. And unfortunately Mr. Seaqueen didn't write it down. And then Ms. Wonderful, and of course I also watched it and listened to it on the iPad. Nicely telling his own story. That's where the 5,000 rand came in. So I hear you. That's your argument. But I'm going to repeat. Where is the evidence in the main trial? Because it could only come from Mr. Van Rijn. And he did not testify.
He did not testify, my lord, in the main trial.
Mm-hmm.
He testified in the trial within the trial.
Absolutely.
That evidence that he testified about in the trial, within the trial, is not erased. It is in the record. And on that record, he testified that.
So there's no need for trials within trials in the law. If that submission of yours is a valid submission in the law, then we can do away with trials within trials.
My Lord,
We don't have to isolate anything.
a trial within a trial is regulated by law. We cannot erase them. We are not legislators.
But that's what you're arguing by implication. It's right that the evidence in a trial within a trial is not automatically carried over into the main trial. That's right. Sometimes there's an application that the evidence tendered in a trial within a trial on certain respects be incorporated. But then the court must make a ruling. And it was made clear, and I'm sure you made it clear to your client as well, that's one of the reasons why, to my mind, the court should be cautious in giving reasons in a trial within a trial when you admit a statement. Because often you have to make credibility findings. And then if you say, but Mr. Sievenerijn was a bad witness, and I don't believe him, how will Mr. Sievenerijn ever trust the fairness of his trial further? Because the presiding officer had already pronounced on his credibility. Of course, that is exactly why, under systems that have juries, like we used to have until 1961, the jury was not part of the trial within a trial, because the judicial officer should have the ability to compartmentalize and put it aside. Whereas the argument goes, the layperson would not necessarily, because of the lack of training and experience and so on, be able to do that.
On that note, my Lord, still in the trial within a trial. Before we started with the trial within the trial, the nature of the statement was never determined by the court.
You're right.
It is the duty of the court, before a trial within a trial is started, to determine the nature of the statement. Why?
How do you do that? How does a court determine the nature of a statement without seeing the statement?
The court will ask the statement and
then?
read it.
Oh.
As
Where does this happen?
in this case,
Where does this happen? In which court in South Africa does this happen?
in
That the presiding officer looks at the statement before it's been admitted and then say, okay, I think it's a confession. So now we're going in a trial within a trial. Oh, no, I don't think it's a confession. So we're going to go.
in this case, it has happened, my Lord.
I'm being surprised more and more. I told
The court was
this
finished.
morning I was being surprised by things in this case, but now I'm even more surprised.
My Lord, I'm not making a mistake.
You see, normally, Mr. Kabai, and we can go back and forth, normally the parties will say, as in this case, we believe it is an inadmissible confession, or from the state side, an admissible confession. Or, as happened in this case, there was a dispute whether it amounted to a confession or whether it amounted to mere admissions. And, speaking for myself, I believe it's the correct way to do, then you play it safe. Paging, are both of you going to be here tomorrow? Because I know one of you weren't available. You made yourself available. I'm just referring to the state. One of the problems with the date was that we couldn't get a date where everybody was available. Or we can leave that point and we can come back to it after lunch. We're going to take a short adjournment somewhere after one, so and then we can go on with the other points. And you can find the authority and I can have a look at it. There is, of course, in some instances where a court can have a judicial peak. That's different.
The reason why there's that...
And it happens more in civil cases than in criminal cases, where the court is invited to have a judicial peak.
Even in criminal cases, my lord, and the reason for that is that admissions and confessions, they've got different requirements. For admissions, it's lesser. For confessions, it's more. So before we go to a trial, within a trial, we have to know what are we doing.
So you give the statement to the presiding officer, and the presiding officer says, this is a confession. So now we're going to go into a trial.
My lord?
Is that the procedure?
I will stick to the authority. The authority says,
before a
trial within a trial starts, the judicial officer or the presiding officer has to determine the nature of the statement.
No. Please get volume 2. That way, please. It's on my desk on the side here on the shelf. That procedure is I take it in volume 2 of the 2A. Not going to do a search now because I want to listen to you.
I'll give the courts that authority when I get to it. Number 2, Your Worship. After trial within the trial, the court has a duty to make a ruling. If it is accepting that evidence, it has to be specific. Is the evidence that is accepting an admission or confession? The court was silent in both those determinations.
Deliberately so.
Yes.
And I'll tell you why.
Why it was silent?
You admit the statement and you say this is a confession to the judge. Confession is a loaded term. It's an unequivocal admission of guilt of all the elements of the offence. What's the purpose of going on with the trial?
My lord?
So why would a court say that?
My lord?
Other courts might say it. I won't.
My lord?
Never.
I strongly objected
I know.
to that statement, to being termed a confession.
I know you can have your say, but I'll have my way the way I understand the law. And I may be wrong. And if it's a ground of appeal, I'll consider it. Because when I have to consider whether I should grant leave to appeal, it's not what I believe is right, but it's whether the test that we've set out with Mr. Aramson applies.
Thank you, my lord. The following ground still in the trial within the trial. When the court was giving judgment,
Is that where wiping the floor comes in?
it was not a written judgment.
No, I have the transcript here.
My lord, in trial within the trial only, I've got about 3 grounds. I'm still going. Trial within a trial. I had just forgotten the title of this case, but it was being handled by one of the judges in this case, was Justice Mhlanga. This matter was in Bloemfontein. One of the grounds for appeal was interference, interruptions, curtailments. They counted up until 37.
That was long ago.
Up to 37, they were tired. I don't know in this case how many times they're going to count interferences
By me,
by the honorable judge. Interruptions.
in the evidence.
In the evidence, my lord. Curtailment. They are going to pass 37.
So I would set the record.
You are going to be in the book of records, my lord?
That's interesting. I'm listening.
Failure by the state to call those arresting officers. This is not, as the court has said. I'm saying this in passing. Those who arrested my client has broken the chain. The chain has been broken. He was taken to Jacob's Bay by the same police officers. From Jacob's Bay, they took him to sea border officers. Now, where the ground is now, my lord? Sergeant Johnson testified that my client was, after the so-called interviews, was detained at Saldanha police station. It is only my name that is recorded on those police record books. His person, he was detained in a white polo in the presence of Sergeant Johnson. Now my question is, detaining an accused person at the back of a white polo does it amount to an irregularity? Does it amount to violation of his rights? The answer to that is clear. It is no. Second ground to this ground. Sergeant Johnson testified that my client at some stage was taken out from Saldana police station to Seaborder police station, to Seaborder offices. To my surprise, she didn't produce before this court an occurrence book showing that indeed my client was booked out from Saldana police station. Is the court going to allow this violation of my client's rights? This miscarriage of justice? This unlawful detention? The other court will come to a different decision regarding all the grounds that I've specified before this court.
Yeah, nothing.
This lack or this failure of proof that my client was indeed booked out from Saldana police station indicates that the official record was either altered or completed to falsely suggest lawful detention. Whereas my client was snoring in pains at the back of the white polo, being guarded by Sergeant Johnson. All this raises doubts about the legality of the entire arrest and the lawfulness of the trial. False records are not clerical errors. They are deliberate acts that erode the integrity of the criminal justice process. I humbly submit that another court may find that such deception warrants setting aside the conviction. My question is, can justice grow in the soil of falsified records? My answer is no. Second ground, my lord, is about the confession itself. I open this ground with a question. Does taking a statement from an accused who is visibly injured raise a legal presumption of coercion, thereby undermining the voluntariness of the statement? The answer is yes. In terms of Section 219A of the Criminal Procedure Act 51 of 1977 and Section 35(5) of our Constitution, any confession or admission must be made freely and voluntarily. Would you say somebody who is visibly injured has made a statement freely and voluntarily?
219A doesn't deal with confessions. You said 219A says every admission and confessions, but 219A doesn't deal with confessions. 217 deals with confessions, 219A deals with admissions.
My Lord?
Only.
I should have added there 217 because in my sentence followed any confession or admission. I've included these statements.
So that will be the 217.
217 and 219A, yes. Must be made freely and voluntarily. It is even worse in this case. Legal examination was conducted before the statement was taken. Injuries on his body were confirmed, but despite the medical confession of injuries, Brigadier Anana gave instructions for the taking of confession from the appellant. This is not merely a procedural lapse. It goes to the heart of voluntariness. Did my client give that statement voluntarily? No. And the other court may come to a different conclusion or decision to what our honorable court has already reached. Another court may find that the conviction based on such a statement was improperly obtained and must be set aside. Can a braced body yield a fluid? Answer is no. Cannot. Helen was assaulted and strangled. No, covered. Not strangled, my lord. Suffocated with a plastic bag. Does the use of suffocation during interrogation constitute grounds for exclusion of evidence and for declaring the trial unfair? Yes.
Yes, if it can be sustained on the evidence.
The answer to that question is a big yes. Torture is a paramount.
No, it's just coffee.
Okay. Torture is a paramount norm in international and South African law. The appellant was suffocated with a plastic bag. We call it a textbook method of torture. This conduct was never denied by the state and was inadequately investigated.
What do you mean
It was denied. It was denied by the state. I made a mistake there, I'm correcting myself. It was denied by the state, partly. Worship. Why I'm saying partly? When I was cross-examining Sergeant Lumba, I asked Sergeant Lumba, Captain Lumba, I'm sorry, my apologies. When I cross-examined him on this piece of injuries, I asked him, the injuries sustained by my client on the elbows, do they corroborate? Are they consistent with the manner in which he's saying he was tortured? His answer was yes. Then I asked on the knees. On the knees, he said, he doesn't know. Hence I'm saying, this torture was partly the nature of injuries on the elbows of my client. I remember this part because he didn't understand the question. Then the court explained the question to him. He answered.
So I interrupted him.
No, that was not an interruption. No, that one, unfortunately, my lord, was not an interruption. That was not. You explained the question to him? Then he said yes. Now, a police officer, not just a police officer, the forerunner of the investigation, a captain, he said yes. The manner your client was injured with Singapore is consistent with the manner in which he said he was tortured. Where was he tortured? Sea border officers. Who was the supervisor there? Captain Lombard. Who was going up and down, speaking with them? Captain Lombard. Now, my lord, other court will look at this piece of evidence and view it differently from our honorable court. Still on the issue of injuries, Sergeant Forte confirmed and said, yes, I saw injuries from the body of your client. I saw injuries while he was at sea border officers. But he told me he suffered those injuries while falling from a bucket. Now, these are police officers. They are noticing injuries. My client is in their control, in their possession. All of them, they've been telling the court that the police has a standard policy that before anyone is, before a confession is taken from anyone, that person must be taken from for medical examination. Let me say, at that stage of the torture, they didn't think at that stage that it was supposed to be taken for confession. Police care. What happened to the police care, my lord? We are seeing somebody is injured. You don't think of taking this person for medical examination. Especially that this person, the court will stop me from this submission I'm going to say. Especially that...
Just now you're going to say I'm interrupting.
Those interruptions are going to be counted in group one day.
You can only get there with my permission. No, on a more serious note.
But I've already said.
I understand the argument.
Yes, ma'am.
But again, I'm going to repeat to you. The facts are what they are. And the evidence gets onto the court record in the manner that they come. And counsel often, clients give instructions, they've made an election, and you try your best to argue. So, I've noticed it's 1:45. I don't want to interrupt you, so go to a point where you feel it's comfortable. Take a break. Before you go on to the next point, maybe, then we take like a half an hour break, just to give everybody an opportunity to breathe, and some of us...
Thank you, my lord. This ground is in a form of a question. Why did the court stop the defense when the defense was making reference to international law during the address in a trial?
So take me...
That's a ground, my lord.
Take me to that case that you wanted to refer to.
R. versus Collins.
Which one? There are two. Is it the one that you couldn't find at the time? I found a case, Rex versus Collins.
That's Collins, my lord?
That's the one that was decided on the 9th of April 1987 in the Canadian Supreme Court.
My lord? I don't
That's
know.
the one that deals with the admissibility of evidence.
My lord?
So, because
sorry.
I couldn't on the reference we've had then, and in your heads there were no references. So I found two cases under Rex versus Collins. The one is in the UK, but it has got nothing to do with evidence obtained in an unconstitutional manner. The only one I found is this case, and it's Rex versus Collins. The reference is 1987, 1 SCR 265. It was decided in the Supreme Court of Canada. There was a split bench in that judgment. I'm going to read from the head note. It says, admissibility of evidence, bringing administration of justice into disrepute, drug search, woman search by police in a violent manner, heroin discovered, reasons for suspecting, and of course the question here was whether or not unreasonable search and seizure, whether or not evidence of heroin is inadmissible because bringing administration of justice into disrepute. So what happened in this particular manner, they only had hearsay evidence that she was a drug dealer. And she was searched in an unconstitutional manner. The facts is now not that important, but yeah.
My Lord, that is not the case. I reference the court.
Now, which is the case?
I do have the
Give me the
citation.
Give me the citation.
In my case of arguments.
But I don't have your heads of argument.
Trial within a trial.
No, but give it to me.
Let me finish, my Lord.
Give it to me, then I can find it. Because remember, you couldn't find it.
No.
Now the problem is, Mr. Kabay, let's be frank with each other.
Yes, my Lord.
And it's not the frank that's referred to in section 204.
Yes, my Lord.
I hear what you say. I've got no problem for you criticizing me. It's your right. But I've told you before, and I'm telling you again now, don't quote cases to me that you haven't read. And if you quote a case, it must be on point. You, for example, in the trial within the trial, refer to Shooping. And you said it was a Botswana case. I knew, that's why I told you Heemstra was the judge. Because I knew it wasn't Botswana. Because it was delivered on my birthday in that year. But that's not the reason I remember. Because there were a number of cases that I found. Every time I go through it, I realize that this case was delivered on mine. Wait. It was in Botswana when he was the Chief Justice there. But clearly you didn't read the case. And so you referred me to others where you quoted in a paragraph, totally out of context. Now you can go and argue that if in the event that you I grant you leave or you get it on petition or whatever before another court. But you're making that same mistake again. In this notice, you again refer to that Rex versus Collins. I went to go and search for it. I couldn't find it. This is the only case with that name that I could find. Wait, I'm not done. That deals with the admissibility of evidence that was obtained by the infringement of a constitutional right. Which clearly could be. And you would have, and the case you're referring to in Collins is the one that's in the footnote in the TOE. Whether that person who wrote the chapter read the case or not, I'm not sure. And whether the reference is correct, I'm not sure. It's incumbent upon counsel when they argue matters before a court to ensure that they quote it correctly and that they've read the cases. You would have realized this morning that I was referring to an article. Because that's the article that's quoted in Caleb. Except the citation in the footnote is not correct. Because it doesn't refer to the volume in the Law Journal in 2003 where it was published. So, any further cases, I'm going to take the adjournment now. If you have cases, give it to Mr. Bro. Because I invited you on the 7th to give me the cases, you didn't give it to me. Because when I come back after lunch, I'm set up here, I'm linked up to the libraries. I can draw any case you refer to. And I've actually opened Red Collins, and I've got all the others. I even have Vestas leave to appeal here. And the other case you referred to was Gamma. You didn't mention the name. That you spoke about the SCA. They're all here. So that, and now again you can, in your petition, and I'm saying it on record, because the last time you did this was in Kavala. And you will recall that you wanted to quote the case. And I can't recall which case it was. Then I asked you about the case, and you couldn't give it to me. Then we adjourned. I set up my equipment. I said, okay, now let's find the case. Let's debate it. Then you said, no, you're not going to refer to the case again. So in this application for leave to appeal, you now say that I stormed out of court. I stormed out of court and I was in a very bad mood.
Yes.
No, it's a ground of appeal. Let's debate it. Let us debate it. I've got no issue with that. But if you want to distort facts, let's do it in public. Because remember what you said when on the day that we adjourned, when I said I'm not going to hear the application for leave to appeal. You said you wanted to embarrass me in front of the media. So do that now.
I never used the word embarrass.
That's what you implied.
I never used that
So
word.
give us the cases you're going to refer to. I'm going to take a half an hour adjournment.
Before I do that, my
Yes.
lord, I have to respond to what the court just said.
Yes, you may.
In the international law reference that I made in my address in a trial within a trial, I quoted the whole citation. And that case deals with the exclusion of evidence that is unconstitutionally obtained. When I was making the citation, before I even finished the citation, the court said, why do you refer me to the international law, whereas there are cases locally?
Yes. And you didn't refer me to local cases either that you've read. But let's not debate this now. I'm going to take the adjournment, get the citations, we will open the cases. When I return, we can discuss them. And so that I can consider whether your client has a reasonable prospect of success in an appeal. And I can only do that if I consider your arguments properly. And to consider them properly, I need to see whether I've made a mistake on the law. Because the facts are what they are. It's now 4 minutes to 1. I'm going to take the adjournment till 1:30, 1:30. And if people leave the building, just indicate, we're going to indicate to security that I'm going to resume at 1:30. Your equipment will be safe in the courtroom. Mervyn, do we have a key for that back door? We're going to try and arrange something, get one of the security to come here. And we will tell the security that I'm resuming at 1:30. And you must just tell them, because they will block you, that you're coming to court 19 and that I am resuming at 1:30. Mr. Brill will go to the front door and let them know. If you have an issue, ask security to give us a call and we'll explain to them, because they might have a shift change or something. The court will do.
And the judgment is dated the 26th of February 2020.
13th of Brooks, J, 26th of February 2020. I have it.
I'll humbly take this court to paragraph 24, where Brooks J stated as follows.
24.
Open quotes. It is tried that in establishing whether a statement amounting to a confession complies with the provisions of Section 217 of the Criminal Procedure Act 51 of 1977, the onus rests upon the state. Proof of the admissibility of the confession must be established beyond reasonable doubt. How would you prove that a confession was taken freely and voluntarily? And when we've seen on the video that the confessor, alleged confessor, was limping, open the eyes, closing them, drowsy. And Captain Sikwi, when noticing that his eyes were closed, he will shout his name as a strategy to wake him up. He knew the alleged confessor was not capable of giving the confession due to his drowsiness. This is one of the confessions, my lord, that was not supposed to be admitted by the court. Confession obtained in such physical condition cannot meet the standard that is required by Section 217 of the Criminal Procedure Act 51 of 1977. Further submit that confession was coerced through intimidation and sleep deprivation. It is further submitted that Captain Sikwi observed the accused asleep during the confession session on multiple occasions. It was not once. He repeated shouted at the accused to wake him up, rather than recognizing this is a clear sign that the process ought to have been abandoned. How can a sleeping man confess? And how can a justice system place reliance on such a statement? I'll make reference to the following case, my lord. State versus Zulu. (2004) in brackets 1.
2004. That the judgment of the 7th of May 2003. From which court did it come?
Western Cape.
Give me the reference. It's stated as a Zulu.
Zulu. Z-U-L-U.
Okay. Checking on the Western Cape High Court. Give me the reference.
2004, volume 1.
2004.
SACR. my lord.
Tell me what is the case about? Is it Zulu ZULU?
Yes, my lord. At paragraph 24 in this case, the court held that a confession made in circumstances where the accused is not fully conscious or mentally aware cannot be admissible. That was the principle in this case, my lord.
Yep.
Confession form that was filed in court was inconsistent with the video evidence. Why I say this, my lord, is for the following. The video footage of the alleged confession reveals a substantive and material inconsistency, in that it seems Captain Sikwi is seen flipping through pages, posing several questions about Kelly, and taking extensive notes on the video. Yet the version of the confession form filed with the court contains no such several questions about Kenny or extended notes that was taken. This contradiction is fatal to the authenticity.
Is it a contradiction or an omission in the form because we had the audio and the video that we could listen to and look at? I couldn't see any contradictions. Yes, there were omissions on the form. That's common cause. But were there contradictions or mere omissions on the manuscript?
My lord, on the video, while he was busy taking the alleged confession from my client, Captain Sikwi made a lot of notes. He could even turn the pages, still writing. He posed several questions to my client regarding Kate. But as per the form, it's only one question that he posed regarding Kate. My humble submission on this is that it's not contradiction per se. I'll call it a manipulation of forms. This manipulation is fatal to the authenticity and voluntariness of the confession. If the recorded content materially diverges from the written form, how can the court be satisfied that the confession reflects the accused actual statements? In the case of S versus Tandwa, Tandwa is TA. TAND WA, the 2008 one. SACR?
State versus Tandwa and others. Is that the SCA case?
Yes, my lord.
Correct. That's the robbery at the Standard Bank case.
Yes, my lord. The SA in this matter emphasized that the voluntariness of a confession must be independently verifiable. In this case, that test is impossible. You cannot independently verify that my client gave the confession voluntarily. taking into account his surrounding circumstances, his injury at the time.
So, seeing that you decided to quote that case in this point, did you read that case?
Hello?
Seeing that you refer to Tanda and others, do you read the case?
In this case,
Because there's another important issue in that case that might impact on your application negatively. Of course, there the appeals were dismissed in Tandua. I think it's Cameron, Malambo, and one other judge. But that court also dealt with the whole question of exercising your right to remain silent and not taking the stand, and clearly stating it has consequences. Remember when I spoke in the judgment about remaining silent and that it has consequences? I didn't put a footnote, but this particular case that you're referring to now, for the confessions, that's why I asked you whether it was a Standard Bank robbery case.
yes, my lord. I like
They also deal with that in that judgment, somewhere. I read it some time ago.
it is further my submission, my lord, that my client, his rights to remain silent, whenever explained to him, before the interview, after the interview, what Sergeant Johnson did in the morning of the 5th of March, it's not explanation of rights. What she did, she took the SAP 14 form and signed it at 4 a.m. for all the 3 accused. What is interesting that those 3 accused, they were not at the same place. But Sergeant Johnson signed all those 3 forms at 4 a.m. Was never warned of his rights. Thank you, my lord.
No, I asked you whether you read the case. Did you raise it?
My lord?
I asked you whether you read this case because you raised it.
Yes, I did, my lord.
So what does it say? This particular case. The circumstances are very similar, where one deals with circumstantial evidence and the accused does not testify, of inferences to be drawn. At the trial court, of course, when we dealt with it, there was no need to go back to the later decisions or the decisions of the Supreme Court of Appeal. But you are applying for leave to appeal now, saying that I erred in drawing certain conclusions. So let's deal with it, seeing that our you are open. If you refer to Tandua, I take it you've read the case. I will accept that, unless you tell me that you haven't read it.
I didn't hear the last part of, because if I refer to Tandua, what is going to happen?
I would expect that you've read the case.
Yes, I did, my lord.
So what does Tandua say? The judgment of Cameron J.A., as he then was, about circumstances like our case, where the accused does not take the stand. In the trial court, in this matter, I refer to Busak, the Constitutional Court judgment. Now, of course, Tandua was this case. It was a Standard Bank robbery in Tata. Similar circumstances, circumstances, insofar as it relates to one of the accused.
In Busak, My lord.
No, and here, the court actually, the SCA, also made a point about drawing inferences where the accused then elected not to take the stand, as your client did.
I will start with Usama.
No, I want you to talk to me about Tandwa, because you referred me to the case, and I told you before we took this half-hour adjournment that some people thought they could make longer, that if you refer me to a case, I expect you to have read the case. Now, I've read the case before, not for purposes of today. That's why I could tell you it was a standing bank robbery.
My lord?
But this case is dead against you on some of the other grounds.
On the ground of remaining silent. That's where it is against me, on that ground.
Now, if you refer me to a case, then you must give me the good and the bad. We can leave out the ugly. The good and the bad about the case. Don't quote selectively.
Okay. The bad of Tandwa, my lord, it is against my client remaining silent. That is the side effect. But now, I overstep that argument by saying, even then, an accused has the right to choose whether to remain silent or not. Tandwa is wrong by penalizing the accused by remaining silent.
Well, Tandwa relied on other cases. So if one goes to the discussion, it's in paragraph 53 of the judgment. Reference is made to all cases. No, besides Busak, it refers to both Busak in the year in the Cape, in this courtroom, coincidentally. Let's see, this is not confirmed because I know it was in this courtroom. And then the old case of Osman and Murray versus DDP. And yeah, for the point that
that's the side effect. That's why I didn't even was a side
that's why you didn't go there, because it's against you. So be careful when you quote cases, because the crux of this case, there were different accused. Insofar as it relates to some of the confessions and also the trials within the trials, and then the failure to leave evidence in their own defense. Yeah, I'm with you.
Thank you. Thank you, my lord.
I'm waiting for the next case.
The following ground is that's the second daughter who examined my client testified under oath that she didn't undress my client during examination. If that is the case, my lord, I will humbly submit that that examination was superficial.
Are there any allegations, even from your client in the trial, that he sustained further injuries between the first examination and the second examination?
None, my lord.
And what did the doctor testify? Our examination is patient-centered. He said, ask the patient, you were here this morning. I have a report. Anything else happened? No. Now you take the point, but you didn't make him undress. Why? There's no need to. That's the obvious answer.
My lord, I will argue further.
Yeah.
As a doctor, she didn't have to listen to the patient. He has to confirm.
But he was examined in the morning, Dr. Nell.
Yes, not by this doctor. Yes.
So then he comes back, because remember he went to for the first attempt, and then he was hungry, and he was drowsy, and then he'd take the statement. It's his own evidence. And that's uncontested. That I went to sleep, I went to have something to eat, and I went to sleep, and then I went to the doctor again. I sustained no further injuries. So, why are we splitting hairs over nothing?
My Lord, in that context, we have to go back to the record and remember, why did my client say so? It's because he was threatened.
But it was
Should you tell
But
me?
it was the truth. He didn't sustain any further injuries. So he was just telling the truth. Of course, he might not be used to it, from what I can see in this case. But it's of no moment, speaking for myself at this stage, that the second doctor didn't address it. In fact, if she did, one would have asked, but why? The man tells you, I've got nothing further to show you. And that is a fact. He was in the police cells, sleeping his rust off, having something to eat and then sleeping his rust off, taking the pain tablets that he got the morning. And you see, this comes back as a matter of formality. It's another thing if factually he had more injuries. But we know that didn't happen. On his own version. And that's uncontested.
But my Lord, being all-inclusive, especially in this part of medical examination, even to the first doctor.
So Mr. Kabai, my car has sensors on the tires. And it's not a fancy car, because everybody here now knows what car I drive. If I don't see a light coming on to say I've got a flat tire, I'm not going to walk around the car every time I go and get into the car. I get into the driver's seat and switch on. If there's no light coming on, then I'm okay.
You won't be okay, my Lord.
Okay,
if your mechanic has warned you, even if you see a red light, keep quiet.
Exactly.
You keep quiet because you are scared of your mechanic.
Exactly.
Should you raise that, your mechanic will be after you.
Did you listen to yourself?
I did, my Lord.
All right.
Of most disturbing is the evidence of this second doctor under oath that the
Dr.
during
Zimmer, Dr. Zimmer.
Yeah, thank you, my Lord, Dr. Zimmer, that during the entire day of the examination, he was in the company of the investigating team. Now I sit down.
No,
Yes,
wait.
it is
The doctor was.
Dr. Zimmer.
She was in the company.
In my examination, my Lord, it's on the record.
No, Mr. Kabai. Of course, the record is not transcribed, but we can go back. You can make the submission, but as far as I recall, she had nothing to do with the investigating team. In fact, she was at the hospital because she's in the management position. And we know where the investigating team is. Not near the hospital, because everybody that was transported there on the day were transported by other police officials from other stations that came in specifically to take the persons to the hospital. And the evidence was that was particularly done to keep them away. So insofar as it relates to your client, you will recall, and I can visualize the witness, and that was the last time anybody of the transporting officials had to be called because he was so meticulous to the minute and the kilometer and the landmark. Those are the detectives from Leipzig. And once the state let that witness, the defense backed down. They weren't going to challenge those type of witnesses anymore. Because we were to challenge every small little thing. But that was the final nail in the coffin as to the transporting officials were concerned. You were recalling?
Yes, I do.
He was sitting
my
in the
lord.
back.
I'll put question mark next
Yeah.
to this ground. I'm waiting for the record. my lord.
Yeah, no, if you get leave, you'll have a full record and then you can take a fine, can sharpen all the pencils. I can convince you you're not going to find it. Dr. Zimri was a doctor with a beige clothes. So.
Yes, my lord. Now, my lord, we come to the most crucial issue. All these other issues are crucial also, but this one is most crucial. The issue of a 48-hour safeguard. I raised this. My client was arrested around 2 p.m. on the 4th of March 2024.
It was early morning and those forms indicated was 4 o'clock, but be that as it may, let me hear the submissions.
And his only first appearance with court was the 7th of March. When he appeared in court on the 7th of March, 48-hour period has already lapsed. Yes.
I have to check that, but it was not a point in the trial, never taken in the trial. And I've made my comments earlier about points that were not adjudicated by the trial court. But it was never an issue. And even if that is so, what difference will it make on the grounds of appeal?
My lord, it will make a big difference.
Might have a civil claim against the state.
Because if that is the case, let me not say if that is the case, it means my client is a ghost prisoner, was not supposed to continue with this trial because his 48 hours are lapsed before his first court appearance. That will be a great impact on this marriage.
Yeah.
Now, my lord, I'll come to the hearsay evidence of Miss Smart and of Mr. Peter.
Yes, Ms. Martin, Sufficiency. Okay, let's deal with them individually. Okay. What evidence of Ms. Mart was the hearsay? I saw it in the grounds and what part of Ms. Mart's evidence that I relied on for purposes of the conviction was hearsay?
Thank you, my lord. I parked my car at the garage. I was pouring petrol in my garage. Kelly came and he spoke softly.
Yeah.
That,
And Kelly spoke to her.
yes, that
So-
Joshlin is in a container en route West Africa.
Yeah.
When accused was convicted, he was convicted on exploitation and slavery. The only person who brought evidence closer to that Joshlin is in a container en route.
I didn't find that Joshlin was in a container.
You didn't, my lord. But the verdict is saying you are guilty of human trafficking, kidnapping, exploitation.
He said it himself in the statement I admitted in the that was admitted in the trial. And then he went back the next day. He said 45,000 rand. Not Miss Mark. And I specifically said, in that element, I don't need to find that because it is a child.
Yes,
And
my lord.
remember, I was surprised when I saw the issue about hearsay evidence because Ms. Mark never presented any hearsay evidence. The evidence was admissible because Kelly herself had spoken to Ms. Mark first hand. No hearsay, and that forms part of the greater conspectus of the evidence before the court. And it's not a specific finding against your client. And the same applies to Mr. Kutsi, of course. But we first dealing with Ms. Mark. But maybe if you explain the submission, I might understand it, because I don't. As hearsay.
My lord, it is not, this is not Mrs. Smart's evidence. This is what she was told. Kelly told me.
So, what was the purpose of the presentation of that evidence? And I take it you're referring insofar as it relates to the container on the boat. Kelly was said that she was told by the seer that Joshlin was in a container on a boat on the route to West Africa. So she tells that to Ms. Mark. Now that's hearsay. Ms. Mark now. But only if it's produced at the trial for the truth of the content. That's the definition of hearsay, the last action. Now, it was never introduced into evidence for that purpose. Is, however, some of the evidence that I've admitted under the exceptions of the General Law Amendment Act, having regard to the judgment that I've listened to. Yes, although I've got it in Word, I've let the computer read it to me. It's easier. But nothing in relation to this.
My lord,
There's an old way of, and I haven't heard the argument for a number of years now, when a practitioner is confronted from the bench for presenting something that sounds like hearsay evidence, your immediate response will be to jump up to say, "No, my lord, it's part of the race case line." So Here it was just part of the race gesta. To use the Latin term.
With due respect, my lord, can I ask for a short adjournment?
Certainly. How long do you need, Mr. Kaban? Just so that we can plan, because, you know, when I take the adjournment, I want to come back on time.
I don't think, I'm sorry, my lord, I don't think I'm feeling well.
No, it's
I'm
fine.
sweating.
It's 10 past, shall I give it 12 past? It's about 20 minutes. And then on planning, subject to Mr. Kabai's wellness, we might then proceed with Mr. Sidnarine, and then Mr. Kabai can relax and we take it further afterwards. But parties can discuss it. Let's take the 20 minutes and then see. Do you need anything, Mr. Kabai? No, you didn't have a proper you didn't have a proper lunch break. So, and it's difficult to get out of the building. So, if you need anything like water or maybe a cup of coffee, speak to Mr. Lowe. My office is just somewhere here behind, and then one of the prosecutors can just go with you, and Mr. Blow can fix you a cup of coffee, and you might feel better then. So 20 minutes till 2:30 of the day.
Vanessa, what did you do? My foot is so. It's swelling. Nee, wacht, hè. Ja, is op een ander level. it gets dropped. Just watch now. I'm just going to have to run it. 1.2. Yeah, I was
Sorry? My foot is, I had an operation on, so my foot is just giving in every time. So yeah, it's no problem. But it's almost done, hopefully. Are you speaking next? Are you going to be speaking next? Guys, I'm going to move it, Max. Move it, Max. Can I move it? Yeah, this is the sound the demon is making. I don't know what the hell. Is it, I don't know, is it normal? It's the first time I hear it. It's the look, I know, when put it in there is not going to read, but the one at the back, we take the cord out and just slot it into that other one. Works perfectly.
Judges wants to see counsel quickly before we start. The one I gave you usually works for Everyone ready? Silence equals to rise.
Due to unforeseen circumstances, we're going to take the adjournment now and resume at 9 o'clock tomorrow. I spoke to council outside the courtroom, and we will still be able to finish tomorrow. So instead of starting at 10, as is customary in Cape Town, we will start at 9, and then we will resume the proceedings. I intend, even if we sit late tomorrow, to give the order and judgment on the leave to appeal as well as the 204 session. It's unforeseen and there's no reason to speculate or anything. We need to be compassionate to cooperate.